Hello. In this clip from our Justia webinar, Inclusivity Unlocked, Engaging with People with Disabilities in the Workplace, Christina Wegg walks you through the legal requirements, the professional and ethical rules, and recommendations for the practice of law to engage with people with disabilities. If you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Let's go back to our three buckets. The first one we're going to focus in on now is legal requirements, which I've hit on just a little bit in regards to ADA. So we have legal requirements under American with Disabilities Act, which we'll talk about from an individual who's providing services to the public as well as an employer. We also have Fair Housing Act, Air Carrier Access Act. These are just some of the major federal statutes, acts that we're going to, mention here, but there's also some at the state level. A Fair Housing Act protects those from discrimination when they're renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. It's not just for disabilities. It protects other protected class based on race, religion, sexual orientation, etc. So, and then we also have the Air Carriers Access Act, which actually focused on disabilities in air travel. It applies to all flights to and from or within the U.S. and domestic and foreign air carriers that provide regularly scheduled services to hire to the public. I only bring this up because I want you to be aware that there are lots of regulations out there, not just ADA, that focuses on or encompasses your interactions with people with disabilities. But the one of most relevance for our conversation today in regards to you as an attorney, working with people with disabilities, whether it be your client, opposing counsel, what have you, is American with Disabilities Act. Generally, ADA sets out requirements that apply to employers, state and local governments, businesses that are open to the public, commercial facilities, transportation providers, and telecommunication companies. So that would encompass law firms. ADA protects persons with disabilities, which includes those who have physical or mental impairments that are substantially limits one or more major life activities, like we had mentioned, but it also protects individuals that we had talked about that may be perceived of having a disability or had a disability in the past but do not now, or their interactions with someone who does have a disability and how that may impact their jobs or services. Americans with Disability Act is organized into different titles. These are all the titles. Title I focuses on employment. Title II, Subtitle A, state and local government services, public transit systems. And Title II, businesses that are open to the public, telecommunication, and other important requirements. I just want you to be aware that ADA covers a lot of ground here, but we're just going to focus on a couple of them that are most relevant to this discussion today. So let's look at ADA Title I for employment. What does this mean? So it applies to those employers with 15 or more employees, including state or local governments, employment agencies, and labor unions. Employers must provide people with disabilities an equal opportunity to benefit from the employment-related opportunities available to others, whether that be recruitment, hiring, promotions, training, pay, and social activities. It requires employers to provide reasonable accommodations to employees with disabilities upon request, unless doing so would cause undue hardship for employers. And so examples of reasonable accommodations might be things like providing a reader or interpreter for someone who is blind or hearing impaired, making a schedule change, allowing leave for disability-related treatment or symptoms, reassignment to a vacant position where reasonable accommodation is not possible in the current job. As I said, this is a very general overview of ADA and kind of the skeleton of how it operates. As you can imagine, there's tons of case law out there that drills down on certain things, such as what's reasonable accommodation, which is a case-by-case analysis that's going to look at your employer and the situation and the request, and what's considered an undue hardship for the employer. Another title that I wanted to point out under ADA is looking at from the perspective that as attorneys, we have businesses that are typically open to the public. So you also are regulated by ADA in this regard. Businesses, including law firms, must provide people with disabilities an equal opportunity to access the goods or services that we offer. Our legal counseling. For example, as a business, you must communicate with people with disabilities as effectively as you communicate with others, make reasonable modification to policies, practices, and procedures where needed to make sure that a person with a disability can access the business goods or services, allow service animals to be with their persons even if you have no pet policies, follow specific standards for physical accessibility when building or altering a building or facility, follow specific requirements for ticket sales and testing accommodations, and remove architectural barriers in buildings when it is reasonably available to do so. So with that, we kind of covered very quickly some of the legal requirements that you are required to comply with as an attorney or an individual with a disability that is providing counseling to a client. So it both looks at it from the employer perspective as well as an attorney who's providing counseling. The next bucket that we're going to hit on a little bit is ethical and professional codes. So what is professionalism? Lots of definition and ideas goes back to what is disabilities. But I want to hit on a couple of them because, what does it mean to be professional? Like professional codes that we have. In Ohio, which is where I practice, our bar indicates that it's an adherence by attorneys in their relations with judges, colleagues, clients, employees, and the public to aspirational standards of conduct. The absolute highest standard that we can ask for, not the bare minimum of just complying with the law and ADA, but even higher than that. Another definition I've seen, although difficult to define precisely, professional has been said to encompass ethics, personal integrity, intellectual honesty, independence, civility, excellence, and courage. And then my favorite is the last definition that I found, which really, I think, encompasses exactly what we should all be striving for, is ethical rules represent the minimum standard below which a lawyer conduct may not fall, while notions of professionalism represent the highest standard of conduct that the public has a right to expect of lawyers and to which all lawyers should aspire. So again, as I like to often say, with professionalism or diversity and inclusion, which we'll talk about in a few minutes, is this concept that you are complying with legal requirements does not mean that you are being a professional attorney when you're interacting with people with disabilities. As I like to say, just because you're not required to say good morning to each other in the hallway by law doesn't mean that there's not value in it and that we don't do that at work because it makes a better work experience for everyone who's involved. But in this regard, there are rules that we have to adhere to as attorneys when it comes to professional conduct. Many state bar associations have their own rules, but I'm going to focus on model rules of professional conduct because this is probably being viewed outside of any one state. So let's look at it from the perspective of you are a practicing attorney with a disability. Things that you have to be cognitive of and remember is that you, even if you have a disability, you are still required to comply with these model rules. So for instance, model rule 1.1 requires competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Regardless of my disability, I still have a responsibility to ensure I request accommodations as needed to be an effective attorney. If I do not, then I am not meeting Model Rule 1.1. Model Rule 1.4 goes to communication. A lawyer shall explain a matter to the extent reasonable necessary to prevent the client to make informed decisions regarding the representation. Again, it's on me as an individual with a disability when I'm providing counseling to ensure that I'm able to communicate with the client. For example, I ensure that when I set up a call with a client, I have captioning. That is part of my responsibility to ensure that I'm complying with Model Rule 1.4 communications. Model Rule 1.16 hits on declining or terminating a representation. A lawyer shall not represent a client or where representation has commenced shall withdraw from the representation of a client if lawyer's physical or mental condition materially impairs a lawyer's ability to represent the client. Meaning, if you have a disability, and even with accommodations, you're not able to provide effective counseling to that client, you have an obligation under the model rules to no longer represent that client. You can see where that tension may occur, between the concerns of an employer and the attorney with a disability. So now we're going to look at it from this perspective. So, from the perspective of employing and supervising a lawyer with disability, many of you are aware that under Model Rules 5.1, responsibilities can be passed on to the partner or supervising attorney under the Model Rule 5.1. In the end, if you supervise an attorney, you can be held responsible for ensuring that they too are complying with the professional codes. So you can see that tension that is created there when someone is hiring someone with disability, with the concern as to whether they're going to create additional liabilities for them, and the fact that there could be additional costs in order for them to comply with ADA requirements to get the accommodation needs that they need in order to comply with the model rules of professional conduct that we just spoke about. And then I want to look at the professional code of conduct in regards to providing legal services to a person with a disability. So if you have a client that has a disability, Model Rule 1.14 talks a little bit about if that disability creates a diminished capacity. When a client's capacity to make adequately considered decisions and connections with representation is diminished, whether because of the mental impairment or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So you still have to continue that relationship with the client to the best of your ability, even with a diminished capacity. So it may be one of those situations where your client requires some sort of accommodation in order to ensure that attorney-client relationship continues. And then when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's interest, it may be a situation where certain lawyers are required to seek the appointment of a guardian ad litem or conservator or guardian in some capacity. And then I just want to hit on here again, communication. Model Rule 1.4 comes up in this context as well. If you have a client with a disability, you have a responsibility, a professional responsibility to ensure that you're able to communicate with them. So a great example of that I've heard is you have a client who is deaf and they bring their sister-in-law with them to counseling, and their sister-in-law happens to know ASL for sign language purposes. It's not necessarily appropriate to rely on the sister who just happens to know some ASL in order to communicate with your client. You should ensure that you have someone who can adequately provide ASL interpretation to your deaf client. That is a responsibility under Professional Model Rule 1.4.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.